As has been alluded to, the case is set to begin, the trial is set to begin on August the 7th, which is a little less than 3 weeks from today. Could not agree more, Mr. Bryant, with the statement that you made, that this case is not about Ms. Pryor, it's not about you, Ms. Rourke, it's not about me. It's about whether or not, according to the indictment, Mr. Long shot and killed Vincent Goslyn. We have spent a lot of time this morning. We have spent a lot of time, and there has been a significant amount of attention given to an issue that has nothing to do with the alleged murder in this case. This case has received significant attention because of this issue that we've been discussing this morning that has nothing to do with the case. It's received significant attention with regard to this matter and not for the allegation that is set forth in the indictment. There have been, and I think anyone who sat in the courtroom during the hearing this morning would agree, there have been significant emotional overtones on both sides with regard to consideration of this issue, and I believe that that underscores why this issue is somewhat problematic. Mr. Bryant, I believe you referred to the Kentucky Rules of Professional Conduct, which do prohibit attorneys from having, and I believe they used the word sex in the rules, prohibited them from having sex with their clients. Many would suggest that that type of attorney-client relationship would also represent someone who is on the same team, a phrase that has been turned several times during the testimony this morning. The Kentucky Rules of Professional Conduct, however, do not specifically address whether prosecutors may have relationships with law enforcement officers who are working the case. But the rationale for why it is prohibited for attorneys and their clients, that it could cloud the lawyer's judgment, certainly may have application with regard to police law enforcement relationships as well, and could objectively, the emotional entanglement could objectively raise an issue about whether or not the prosecutor could effectively carry out her duties as a prosecutor in light of that relationship. At a minimum, there is a duty to disclose these types of relationships so the defense can use it if desired in cross-examining the law enforcement officer. Clearly it was not disclosed in this case. Had it been disclosed earlier, had it been disclosed at the outset of the case, the result may or may not be different. But it wasn't disclosed in this case, and if I understood the testimony correctly, it has not been disclosed in any case in which Detective Stokes and Ms. Pryor are both involved. There was referenced in the Courier-Journal article, which I thought was interesting, and I understand it's a newspaper article, but there was referenced in there a situation in another jurisdiction in Illinois where a prosecutor was suspended by her office for failing to disclose her affair with a law enforcement officer who testified for her in a first-degree murder case. The question was asked by Mr. Bryant and answered substantially, as Mr. Bryant indicated, by Ms. Pryor, and that was whether or not, and if an assistant in her office had a case in which he or she had an intimate relationship with a law enforcement officer, whether or not she would take that person, that assistant, off that case. And I wrote it down in quotes because I wanted to be accurate. She said most likely. I don't think she specifically said yes, but she did say most likely, which does tend to acknowledge that there is at least a concern, if not a problem, with that type of relationship. There has been some discussion about the National District Attorneys Association guidelines, and for the record, those are non-binding guidelines, but again, something that is instructive and perhaps can give guidance in situations such as this. I appreciate Ms. Pryor's candid answer that what's at issue with regard to those guidelines is not a subjective standard. In other words, it's not whether the prosecuting attorney believes that he or she has done anything wrong. I believe that Ms. Pryor sincerely believes that she has not done anything wrong. But what the standard is, the objective standard is, whether a fair-minded, objective person would conclude that there might be a problem. So in this case, the question is whether the present situation, the disclosure of the intimate relationship between Ms. Pryor and Detective Stokes would cause a fair-minded, objective observer with regard to the trial of Jared Long to have concerns about whether Ms. Pryor's judgment or ability to administer the law in an objective matter may be compromised. That's the question. At best, this issue is a distraction. It is, at best, an unwanted and unnecessary distraction. At worst, there are potentially very significant legal considerations, and I believe that there are very serious, potentially ethical considerations and implications for the Commonwealth's attorney. Either way, this issue has had the effect of undermining confidence in the integrity of the judicial system and potentially the integrity of the verdict in this case. It unnecessarily raises questions that should not have to be asked in a murder trial. It is, in fact, the goal in every case, not only to avoid impropriety, but to avoid the appearance of impropriety. And for these reasons, the court believes it is best for everyone involved, for the Commonwealth's attorney to be disqualified from prosecuting this case. The court believes it is best for Mr. Long, Mr. Goslyn, and everybody who has an interest in and a concern with this particular case that is before the court. The court also believes that it's best for the Commonwealth's attorney. I realize, Ms. Pryor, that you disagree with my ruling. I realize that you may not, in fact, I'm sure you don't like my ruling, but I believe ultimately my ruling is best for you as well. This issue is certain to be litigated at the trial. If you continue in this case, it would be relitigated in the appellate courts. I also believe that there is a substantial likelihood that it would be litigated in any forums that address ethical issues regarding prosecutors. And finally, I believe it's best for our judicial system as a whole to do everything that we can, and ultimately this is my responsibility in this court, that we do everything that we can to avoid not only impropriety, but also the appearance of impropriety. There should not be any reason, apart from consideration of the evidence and the facts, that someone would have reason to complain about or object to or express concern about the legitimacy of a verdict in this court. And I believe, and I'm afraid, that if the Commonwealth's attorney continued in this case, we would give rise to a number of those concerns, which is unnecessary, and in this case it is avoidable, and it is avoidable by granting the defendant's motion to disqualify the Commonwealth's attorney. So it is hereby ordered by the court, and I'll prepare a separate written order, that the Commonwealth's attorney of Christian County and the Commonwealth's attorney's assistants are disqualified from prosecuting the case of Commonwealth of Kentucky versus Jared Tabor Long, Christian Circuit Court, indictment number 12 CR 00169. Christian County Commonwealth's attorney is also directed to contact the Kentucky Attorney General's office and to request the appointment of a special prosecutor to proceed with the prosecution of this case. I don't believe it's fair to expect a special prosecutor to be prepared to try the case. There are, as everyone knows, a number of other evidentiary issues that we didn't even get to today that need to be resolved. So I'm going to vacate the trial that's scheduled to begin on August the 7th. I'm going to set this for a pretrial conference. I'd like to set it on August the 16th at 1 o'clock. It is my hope that gives us about a month. It is my hope and expectation that a special prosecutor could not only be appointed by that time, but it could also attend that hearing and participate in preparing this case for trial. It would be my hope, Mr. Bryant, Ms. Rourke, that this case could be tried. It's unlikely it could be tried by the end of the year because of the court's current trial docket, but it's my hope that it could be tried sometime during the beginning of 2018, and that's certainly my goal. All right, with that, then, ladies and gentlemen, this matter is adjourned. Thank you.